Heien v. North Carolina, Supreme Court, 2014. Chief Justice Roberts delivered the opinion of the court. The Fourth Amendment prohibits unreasonable searches and seizures. Under this standard, a search or seizure may be permissible even though the justification for the action includes a reasonable factual mistake. An officer might, for example, stop a motorist for traveling alone in a high-occupancy vehicle lane, only to discover upon approaching the car that two children are slumped over asleep in the back seat. The driver has not violated the law, but neither has the officer violated the Fourth Amendment. But what if the police officer's reasonable mistake is not one of fact but of the law? In this case, an officer stopped a vehicle because one of its two brake lights was out, but a court later determined that a single working brake light was all the law required. The question presented is whether such a mistake of law can nonetheless give rise to the reasonable suspicion necessary to uphold the seizure under the Fourth Amendment. We hold that it can. Because the officer's mistake about the brake light law was reasonable, the stop in this case was lawful under the Fourth Amendment. 1. On the morning of April 29, 2009, Sergeant Matt DeReese of Surry County Sheriff's Department sat in his patrol car near Dobson, North Carolina, observing northbound traffic on Interstate 77. Shortly before 8 a.m., a Ford Escort passed by. DeReese thought the driver looked very stiff and nervous, so he pulled onto the interstate and began following the Escort. A few miles down the road, the Escort braked as it approached a slower vehicle, but only the left brake light came on. Noting the faulty right brake light, DeReese activated his vehicle's lights and pulled the Escort over. Two men were in the car. Maynor Javier Vasquez sat behind the wheel, and petitioner Nicholas Brady Heien lay across the rear seat. Sergeant DeReese explained to Vasquez that as long as his license and registration checked out, he would receive only a warning ticket for the broken brake light. A records check revealed no problems with the documents, and DeReese gave Vasquez the warning ticket. But DeReese had become suspicious during the course of the stop. Vasquez appeared nervous. Heien remained lying down the entire time, and the two gave inconsistent answers about their destination. DeReese asked Vasquez if he would be willing to answer some questions. Vasquez assented, and DeReese asked whether the men were transporting various types of contraband. Told no, DeReese asked whether he could search the Escort. Vasquez said he had no objection, but told DeReese he should ask Heien because Heien owned the car. Heien gave his consent, and DeReese, aided by a fellow officer who had since arrived, began a thorough search of the vehicle. In the side compartment of a duffel bag, DeReese found a sandwich bag containing cocaine. Officers arrested both men. The state charged Heien with attempted trafficking in cocaine. Heien moved to suppress the evidence seized from the car, contending that the stop and search had violated the Fourth Amendment of the United States Constitution. After a hearing at which both officers testified and the state played a video recording of the stop, the trial court denied the suppression motion, concluding that the faulty brake light had given Sergeant DeReese reasonable suspicion to initiate the stop, and that Heien's subsequent consent to the search was valid. Heien pleaded guilty, but reserved his right to appeal the suppression decision. The North Carolina Court of Appeals reversed. The initial stop was not valid, the court held, because driving with only one working brake light was not actually a violation of North Carolina law. The relevant provision of the Vehicle Code provides that a car must be equipped with a stop lamp on the rear of the vehicle. The stop lamp shall display a red or amber light visible from a distance of not less than 100 feet to the rear of normal sunlight, and shall be actuated upon application of the service foot brake. The stop lamp may be incorporated into a unit with one or more rear lamps. The state appealed, and the North Carolina Supreme Court reversed. A traffic stop for a suspected violation of law is a seizure of the occupants of the vehicle and therefore must be conducted in accordance with the Fourth Amendment. All parties agree that to justify this type of seizure, officers need only reasonable suspicion, that is, a particularized and objective basis for suspecting the particular person stopped of breaking the law. The question here is whether reasonable suspicion can rest on a mistaken understanding of the scope of the legal prohibition. We hold that it can. As the text indicates, and we have repeatedly affirmed, the ultimate touchstone of the Fourth Amendment is reasonableness. To be reasonable is not to be perfect, and so the Fourth Amendment allows for some mistakes on the part of government officials, giving them fair leeway for enforcing the law in the community's protection. We have recognized that searches and seizures based on mistakes of fact can be reasonable. The warrantless search of a home, for instance, is reasonable if undertaken with the consent of a resident, and remains lawful when officers obtain the consent of someone who reasonably appears to be, but is not, in fact, a resident. By the same token, if officers with probable cause to arrest a suspect mistakenly arrest an individual matching the suspect's description, neither the seizure nor an accompanying search of the arrestee would be unlawful. The limit is that the mistake must be those of reasonable men. But reasonable men make mistakes of law, too, and such mistakes are no less compatible with the concept of reasonable suspicion. Reasonable suspicion arises from the combination of an officer's understanding of the facts and his understanding of the relevant law. The officer may be reasonably mistaken on either ground. Whether the facts turn out to be not what was thought, or the law turns out to be not what was thought, the result is the same. The facts are outside the scope of the law. There is no reason under the text of the Fourth Amendment or our precedents why this same result should be acceptable when reached by way of a reasonable mistake of fact, but not when reached by way of a similarly reasonable mistake of law. Contrary to the suggestion of Heien and Amici, our decision does not discourage officers from learning the law. The Fourth Amendment tolerates only reasonable mistakes, and those mistakes, whether of fact or of law, must be objectively reasonable. We do not examine the subjective understanding of the particular officer involved, and the inquiry is not as forgiving as the one employed in the distinct context of deciding whether an officer is entitled to qualified immunity from a constitutional or statutory violation. Thus, an officer can gain no Fourth Amendment advantage through a sloppy study of the laws he is duty-bound to enforce. Finally, Heien and Amici point out the well-known maxim, ignorance of the law is no excuse, and contained that it is fundamentally unfair to let police officers get away with mistakes of law when the citizenry is accorded no such leeway. Though this argument has a certain rhetorical appeal, it misconceives the implication of the maxim. The true symmetry is this. Just as an individual generally cannot escape criminal liability based on a mistaken understanding of the law, so too the government cannot impose criminal liability based on a mistaken understanding of the law. If the law required 2 working brake lights, Heien could not escape a ticket by claiming he reasonably thought he only needed 1. If the law required only 1, Sergeant Durice could not issue a valid ticket by claiming he reasonably thought drivers needed 2. But just because mistakes of law cannot justify either the imposition or the avoidance of criminal liability, it does not follow that they cannot justify an investigatory stop. And Heien is not appealing a brake light ticket. He is appealing a cocaine trafficking conviction as to which there is no asserted mistake of fact or law. Here we have little difficulty concluding that the officer's error of law was reasonable. Although the North Carolina statute at issue refers to a stop lamp, suggesting the need for only a single working brake light, it also provides that the stop lamp may be incorporated into a unit with 1 or more other real lamps. The use of other suggests to the everyday reader of English that a stop lamp is a type of rear lamp. And another subsection of the same provision requires that vehicles have all originally equipped rear lamps or the equivalent in good working order, arguably indicating that if a vehicle has multiple stop lamps, all must be functional. This stop lamp provision, moreover, has never been previously construed by North Carolina's appellate courts. It was thus objectively reasonable for an officer in Sergeant Durice's position to think that Heien's faulty right brake light was a violation of North Carolina law. And because the mistake of law was reasonable, there was reasonable suspicion justifying the stop.